Hi, everybody. Welcome to another episode of Tax Sale Insiders. I'm your host. I'm Brian Seidensticker. I'm the CEO of Tax Sale Resources. And with me today, I have a new guest that hasn't joined us before, Greg Scaglione with Coley Jessen. Greg, welcome.
Hey, good afternoon.
And I guess for those of you who haven't been listening real long or just getting into the industry, there's a rare instance in tax sale history, quite frankly, of exciting times. I usually jokingly said that in the past, but there's been a case that's made it all the way through the U.S. Supreme Court. Did get an opinion issued at the end of May this year, and that happens to be the Tyler versus Hennepin County case, and obviously that had pretty wide ranging effects on the industry and different effects on states. One of those being Nebraska, and Greg, I know you're representing one of the tax law investors there in a case that was basically affected by that opinion. So I guess maybe we'll start with can you get us up to speed on a little bit of background on the case that I guess you're arguing on behalf of?
Happy to do it, Brian. So my client, Continental Resources, based in Nebraska, bought a tax certificate from Scottsbluff County. And after waiting the statutory time period to allow the homeowner to pay the tax and the interest, that did not happen. So my client applied for a tax deed. And the county issued that tax deed to my client, at which point they became the owner of the property. My client then brought a quiet title action to have title deemed fully in their name and ultimately to gain possession of the property. So that action was brought. The homeowners, through the Nebraska legal aid, brought a defense and counterclaims, and they added in the county treasurer, and our attorney general, claiming that the Nebraska tax certificate and tax deed process is unconstitutional on many grounds, many of them similar to Tyler, that there was a unlawful taking of the property without payment of fair compensation, that there was an excess penalty. And all of those constitutional challenges were rejected by the trial court. So we went up to the Nebraska Supreme Court, and the Nebraska Supreme Court, relying on its prior cases and some cases from the U.S. Supreme Court, also found that all of those legal and statutory challenges should be denied. And so we won at the Nebraska Supreme Court. The homeowner then appealed to the U.S. Supreme Court. And at that time, Tyler versus Hennepin County was already pending before the U.S. Supreme Court. So what the Supreme Court said was our case would be put on hold and would await the ruling in Tyler. And then, of course, in 2023, when the Tyler opinion came down, the U.S. Supreme Court, in a very short opinion, simply said that our victory that we had won from the Nebraska Supreme Court was reversed, and that it was remanded for further proceedings consistent with Tyler. So there wasn't any instruction to us or to the Nebraska courts as to exactly what to do, other than read Tyler and then decide what should happen to this Nebraska opinion based on the statutes in Nebraska. So where we are today is that we have filed briefs with the Nebraska Supreme Court, as has the homeowner, and in those briefs, we're suggesting what the Supreme Court should do in light of Tyler. And we are scheduled for oral arguments in January of 2024. I would expect a ruling from the Nebraska Supreme Court by probably April of 2024 is the current timeline. So that's where we sit today.
Got it. Okay. So now the arguments or the oral, I guess, can you give us a quick summary of the briefs that have been submitted, I guess, from the homeowner side as well as your side?
So I'll give you the homeowner's summary first. they're saying that in light of Tyler, which Tyler was a little different because in that case, the county brought a foreclosure action to help collect the unpaid tax, interest, and cost. And that foreclosure went forward, and the county actually became the owner of the property. And the Supreme Court said that was an unlawful taking, meaning that when the state takes property from a private individual, it has to pay fair compensation. And the Supreme Court found in Tyler that because the county kept the quote equity, the amount in excess of the tax when it kept the property's title, that was an unlawful taking without fair compensation. So that case is a little different than ours because we did not have a foreclosure. The county of Scottsbluff never became the title owner of the property. Instead, as I mentioned, we just applied for a tax deed and the county gave it to us and we became the owner, my client. So the argument in our case, and the homeowners are called the Fairs. So the Fairs are arguing that this is an unlawful taking without fair compensation. In other words, I'm going to round these numbers. Let's say there was $5,000 due in taxes, and let's say they claim that their property is worth $55,000. Well, they're saying that difference or $50,000 of equity is lost to them because they now are no longer the owner of the property and they never got paid by anyone any equity in the property that was over and above the tax and the accrued interest. So that's their primary argument. They do add another argument focused on the excessive penalty or fine, which the U.S. Supreme Court didn't rule on, but you'll note in some of the concurring opinions, they added that may be an additional ground to challenge some of these tax certificate statutes. So that's their argument.
Okay. And then what's your argument or the investor's argument?
So our counter argument is, and again, I'm going to separate us from the county because the one thing that Tyler did make clear is that the government agencies like counties or subdivisions may seize and sell property to collect an unpaid tax. They absolutely affirm that. What they said, though, is the question is, what do you do with the equity? Obviously, that raises questions. How do you calculate the equity and who pays it? Those are issues that we're arguing to the Nebraska Supreme Court. So from my client's perspective, the certificate holder, here is our argument. Since we received a tax deed, and since Tyler said property can be seized and sold to pay tax, our view is our tax deed is valid. And there's no reason to invalidate that tax deed. So my client is the owner of the property. The question then becomes, what should be done, if anything, with the equity? Well, our view is the county is the one who seized and sold the property because they are the ones who issued the tax deed. They are the grantor under the deed. So they seized the property and they sold it to us. So in our view, what the Supreme Court should do is, number one, they should affirm the validity of our deed and deem that we are the fee simple holder of the property. And number two, to the extent that the Fairs, the homeowners, want to argue that they're entitled to some part of the equity, they should make that claim against the county, because only the county had the authority to take property and only they were the grantor of that property to us. They shouldn't go back on the deal that was made with tax certificate holders. And that deal is basically this: the county does not want to be in the position to become a collector of unpaid taxes because collection has risk. You may not get it fully collected. Collection has delay. You're almost always going to collect it much later. And tax collection costs money. You have to hire lawyers. So the benefit that the county gets by selling a tax certificate is they get paid immediately the full amount of the tax, and they can put that immediately to public use. And they don't have to incur the cost of collection. They don't have to incur any risk. They don't have to incur any delay. So that's the benefit to the county. Well, what's the benefit in Nebraska to people who purchase certificates? Well, in addition to getting an interest rate applied to the tax they paid, if the property owner doesn't redeem after a pretty extended long period of time to redeem and pay the tax, then we have the promise that the county will transfer the property to us by way of a tax deed so long as all the prerequisites are met. The main one being the tax and the interest is not paid. That's the deal that's made with tax certificates. And so the purchaser should never have to pay the equity. That was part of the deal of fronting the tax, was one day we might have an opportunity to own the property, including any equity therein. So in our view, we believe the county who made a deal with us and who takes the property and gives a tax deed, only the county would owe any equity. And so we don't really have an argument to be made there. We think that's between the county and the property owner to argue, is there equity and how much should be paid, and et cetera, et cetera. My client just wants clear title and wants to move on with the deal it made with the county.
Got it. Now, I guess a couple clarifying comments for the audience that aren't necessarily as familiar with Nebraska. So Nebraska sale process, sells a lien, right? And there's not a premium bid process for the lien in Nebraska. There's some other states where you bid a premium. Granted, it's not a lot, but that creates this surplus. And there's certainly states that are responding to Tyler Hennepin because their lien bidding process creates a surplus, right? That surplus needs to be available to the prior owner. And in a couple of states scenarios, they've recognized, that's something that's broken. That surplus shouldn't go to the county, and that should be available to the previous owner. Nebraska is unique in that there's really no surplus generated, right, at the sale. It's a sale of the certificate, basically the taxes that are owed at the time. The other thing that I most of the listeners probably know this, but we're not talking about 100% of all the liens that sold end up in a deed, right? We're talking about a very, very small fraction of the liens that are sold that ever end up in that scenario, because most homeowners either redeem, or most homeowners, if there is equity in the home, maybe sell it or do something to be able to redeem that property before it ever gets to that scenario. The other comment is more from another investor we interviewed. He's based in New Jersey, and I don't know if this holds for Nebraska specifically, but he said even though it's a very small fraction of real estate we end up with, and even that fraction we end up with, we actually lose money on more than half, because by the time you pay legal costs, all these other things, we are not making anything on half, and then there's a very small percentage where we might make something, but it's certainly not a planned event to make a lot from the few that end up in a positive scenario at the end of the day. So obviously the fares sounds like they may have been in that small bucket of there's potential additional value in that home, but that's an argument to be had between them and the county, right? And I guess in the investor's opinion in Nebraska. That sound correct?
Yeah, so a couple of points there. One, again, I think the point gets back to the deal that was made. When particularly institutional purchasers of tax certificates purchase large number of certificates, they're counting on, there will be some that are losses, right, as you point out, and there'll be some that maybe have some equity. And so they go in calculating that risk and counting on some of the properties having an over to make up for some of the properties that have a loss. That's why they take the risk of the business. Well, to change the deal now for all the tax deeds that have already been issued and the certificates purchased, and said now a tax certificate purchaser will never keep the owner, well, that's changing the deal that they made when they purchased their certificate. So that's why I will argue to the Nebraska Supreme Court that it's really the county's responsibility, to the extent there is any, to pay for, quote, equity. that's really between the county and the property owner, not us. We made a deal that we take the risk of having a loss or the benefit in some instances of having a little bit of equity, in a sense, come to us to make up the difference. Then the second point is, in Nebraska, we are switching to, for 2024 going forward, we are switching to something close to a judicial foreclosure, and the judicial foreclosure will then set a price, and any equity over and above liens that are due would go back to the homeowner. So going forward from 2020, for any tax certificate purchase 2024 and forward, the Nebraska legislature has tried to cure this issue. So really what we're talking about in Nebraska are certificates issued in 2023 and before. And then please keep in mind that there is a statute of limitation to bring these types of claims, and they're in the nature of an inverse condemnation, which in Nebraska would be 2 years. So really, Brian, what we're looking at is looking back probably just 2 years. So you're going 23, 22, maybe back to 21. It's that window that's in play, because prospectively in 24, this will be resolved. So the county, in our view, is really just going to have to deal with about a 2 to 3 year problem here in Nebraska.
Got it. Now you're the timeline you kind of laid out. You make oral arguments in January, and I think you said April, roughly. Expecting an answer. Is that answer that would come down? Is that kind of a final answer, or is that it is an opinion that can be appealed on either party? I guess what would happen at that point? I guess if you could kind of look into a crystal ball, if you will.
So we came to the Supreme Court by virtue of competing summary judgments. So there actually was not a trial. Both sides said the facts were not in controversy and just decided on constitutional and statutory grounds. So based on the Tyler opinion, it's likely that at least parts of the prior summary judgment might be undone and thus remanded for further proceeding. I think the parts relating to my client, none of them should be undone. And really the only issues that should go back are those between the county and the homeowner. That's my view. We'll see how the Supreme Court resolves that. So I do expect that there may be some portion of the case that's remanded for further proceedings. The thing that remains a little unclear, Brian, is whether the Supreme Court of Nebraska will issue some guidance here, both to counties and tax certificate holders involved in this case and just residing in the state, that in general, here's how we're going to address some of these issues, to give some guidance. Or they may just send it back to the trial court to make those decisions on a first impression basis, and then they would be appealed back up to the Supreme Court for them to make a final decision then. So all that said, I don't think we're going to have the final answer to all questions in April. The debate will continue.
Is this something that will be debated, continuing to be debated 5 years, 10 years down the road in your view, or is it something that will get resolved at some point in the next couple of years?
Well, I do think it'll cut off by, let's say, December of 25, because the 2-year statute limitation for inverse condemnation. So if you bought a certificate in Nebraska on December 30th, 2023, these types of arguments of, again, they're in the nature of inverse condemnation, would end in 2025. So it's probably a look back of 2 to 3 years and a look forward of 2. So I think we have about a 5-year window here. And as you point out accurately, most of these certificates are redeemed. So it's getting to be a smaller and smaller universe. But the fact that there's any cases out there, and Tyler has given some traction and momentum to these arguments, there will be quite a bit of litigation on these issues.
Yeah. Well, it's interesting to me in talking to attorneys in other states is I'm not an expert in the other state statutes. I guess the benefit in Nebraska from a liability standpoint, on the county, right, or the investor, which I think is really the main argument here, if there is a liability at all, right, is there's at least a statute of limitation to that. I don't know if that holds in every state, but there's certainly other states that have a tax lien process very similar to Nebraska that I'm sure investors and attorneys and judges are watching to see what does Nebraska say, and the ramifications might be larger in other states as they might be in Nebraska. So I guess pivoting a little bit back to the foreclosure process that's being put in place starting January of 2024. That's for liens sold as of January 2024, right? So it would be liens that end up in the situation. Is it 2-year redemption period in Nebraska? Is that
two to three?
2 to 3. So we're looking at that really not coming into play or those types of sales happening until 2026-ish at the earliest. And so any lien that was sold prior to then is still going to follow the same process that was in play at the time of the sale of the lien, not this new foreclosure law. Is that accurate?
Not quite.
Okay.
Because what's happening right now is counties in Nebraska don't know what to do.
Okay.
So so let's say you purchased a certificate in 2022, or I'm sorry, you purchased it some time ago, but now it's ripe for an application to convert that into a tax deed. So if in November of 2023, you go to a county in Nebraska and say, all the conditions have been met, I'm applying for a tax deed and I want my deed.
Right.
The counties don't know what to do at this point because Tyler, they understand and they've taken the position Tyler might prohibit us from issuing a tax deed. Go do a judicial foreclosure now. Some counties have taken that position. Other counties have issued the deed, and other counties are still mulling it. So again,
okay,
it's unclear and ununiform what counties are doing. And again, I think a lot of eyes will be on the Nebraska Supreme Court. But again, they could just say remanded for further proceedings, and we may not have a comprehensive answer here, even in the second quarter of 2024. So Tyler has thrown so many questions at all of the participants in this arena, and there's no clear answers. And so from my client's perspective as a tax certificate purchaser, our view is a deal was made. We're governed by the statutes that were in effect when we bought the certificate. If we qualify for a tax deed, we should be given a tax deed because Tyler said property can be seized and sold to satisfy unpaid taxes. Mm-hmm. So in our view, we should get our tax deed and we should be allowed to move on. This debate really is between the county and the property owner, not us. That's our view.
Got it. Which, I guess I'm only an opinion, and I'm certainly not an attorney. I mean, it certainly makes sense to me. I can also see the county sitting. So counties, do they have an argument that they're providing in January as well? Since it sounds like they have a pretty big stake in the overall decision here.
They have been asked by the Supreme Court, or at least the county involved here, Scottsbluff. They've been asked to submit a brief and to suggest to the Supreme Court what they believe is the proper application of Tyler. And our Nebraska Attorney General's office has been asked by our Supreme Court to submit briefs to argue from the state's perspective who passed the statute, what do they think? And I think to date, the Attorney General has chosen not to file anything yet. And I don't think I've seen anything from the county yet either. So that's still to be determined.
Got it. Well, that'll be interesting because obviously, if they should be right, at least arguing on their behalf, and I'm sure that'll be an interesting change in the case depending on what their argument is. So maybe we'll be talking here in a month and a half or 2 months when that does come out, and we need to get the message out to the community.
Right.
Well, Greg, is there any other kind of items of note or potential changes that you're aware of that we need to touch on today?
Those are the main ones. we're really in limbo here until we get a
Yeah.
decision. And again, even with the decision, it may not answer many. It certainly may not answer all of these questions. So counties are going to be in a difficult spot trying to decide what to do. Tax certificate holders are going to be in a difficult spot. If they're denied a tax deed, they may have to sue the county to compel the issuance of a tax deed. That's called a mandamus action. Or they may have to proceed with a judicial foreclosure and then sue the county for having to go through that delay and cost of doing that when they should have just received a deed. So it puts tax certificates holders in a, like, what do we do? And then even the courts, like if the Supreme Court ultimately remands this back to the trial court's going to have to decide a whole new area of law that was well settled, that has been completely uprooted. And the courts are going to have to come up with how are they going to figure these issues out. So we're going to be in a state of flux and probably inconsistent rulings from state to state for some period of time, is my guess.
Got it. Well, for anybody listening that is active in Nebraska and doesn't know about this case, I'd be surprised if they didn't, but there might be a few out there. If you hold a lien, right, definitely, don't assume that you might be getting a tax deed automatically. You're gonna find out when you go to request it whether the county's going to say, yes, here you go. No, got to go to foreclosure, or we're not issuing anything right now, TBD. So definitely plan for that. And then obviously, definitely be listening in or watching this in January and then, April-ish timeframe, whenever that comes out. I think it's anybody active in states that operate like Nebraska. So if you're an Arizona investor, a Colorado, Missouri, New Jersey, DC, several other states that operate very similar, you should be watching this because this could have potential ramifications in those states, depending on what the Supreme Court in Nebraska says. Well, Greg, I immensely appreciate your time. Thank you for getting me up to speed, educating the audience. I'll probably be bugging you here in a couple of months to see how it went in January, and then maybe again in April, May, to see how it all went down. So thank you again. I appreciate it.
Very welcome, Brian. Thank you.
All right. Have a great one.
All right.
Good luck, everybody.